Okay, hello everyone. Good morning. Welcome to our Thursday morning CPD session, how to prepare employer-sponsored visas uh, workshop. So my name is Dennis. I'll be your presenter today. Just going to run through some housekeeping first of all, particularly for those attending online. Omara has made some changes, or should I say, they've given us advice that you need to attend the full session in order to claim points. So it's really important that everyone online, for our record keeping purposes, stays logged in for the entire 3 hour session. We're running these sessions in 1.5 hour blocks, so between 9:15 to 10:45 and then 11 to 12:30. But please remain signed in for the entire session. Um, Anyone online, it would be helpful for us if you can put in your name and your MAN so that we have a record that you're signed in and remain signed in for the entire session. Our office has actually been calling each of you this morning as well, just to ensure that you're all signed in and attending a full session. So this is for reporting your points, so it's really important. So I just wanted to get that um, policy change communicated to everybody. Apart from that, there's also, as I mentioned, we're having these sessions run. It's a 3 hour CPD, got 1.5 hour blocks where, uh, if for any questions or comments or just to answer any of my questions, feel free to use the chat or the question and answer function. I'll be looking at that periodically. So that's that all that we need to cover. Yep, great. Okay, so um, just a bit of background to myself. As I mentioned, my name's Dennis. I am an accredited specialist in immigration law. I've been working in this industry for about 15 years to date. So it's been, it's been a fairly long ride in this immigration space. And I recall one of the first visas, in fact, the very first visa I ever did was a sponsored visa. So back in the day, it was still a 457. So there's been obviously some evolution in the sponsored framework. Now it's the 482, and that's gone through multiple name changes, multiple iterations of the particular visa. It is a very critical part of the migration space. So besides general skilled migration, sponsored visas are one of the few visas that people are able to come migrate on a more longer term or permanent basis based on their skills, based on their work and qualifications, uh, parallel to the family and refugee protection space. So it's a very important visa to know. Like I said, one of the first visas I did was a 457, and to date, I'm still doing sponsored visas. It's the main sort of bread and butter of a lot of work that we receive for through just the services that we provide, and it's a lucrative and a very, very important area. So good to know everything about it. Okay, so we're going to cover all the key sponsored visas today. Um, I've set a chart out for everyone to see. Just so the essential sponsored visas would be the 482, which is the temporary sponsored visa, currently known as Skills in Demand. The 186, which is the permanent visa, so that can be applied for through either a 482 transition scheme or through the direct entry pathway. And then the 494, which is the regional visa, also sponsored. Certain features between the subclasses. So the 482 and the 494 are both three-stage processes. So sponsorship, nomination, and visa. Sponsorship, all three applications can be made at the same time, but each of them are sequential, so they're all sort of reliant on the one that precedes it. Okay, so you can make a sponsorship, but you can't make a nomination application unless you've already applied for a sponsorship, and you can't make a visa application unless you've been made a nomination application. And of course, each of them are also sequentially a process. So the visa can't be approved until the nomination is approved, and the nomination can't be approved until the sponsorship is approved. So 482, 494, both three-stage processes. The 186 is a two-stage process. The nomination and sponsorship criteria are in substance covered under just the same nomination application, Reg 5.19. And then the visa, to make a valid visa application, then, as mentioned, either a nomination needs to have been made or approved. Okay, just sound could be coming. Sorry, there's attend the session with another presenter. Yes, there were no issues on work. Sorry. Are we having some audio issues? So what I can do is I can hold. Okay. Is this better? I'm just holding the microphone just close to. Okay. All right, Raymond, can you remove the sound from one of your devices and try? Because currently you're logged on to two devices. I've just, yeah, I've been informed you've. Sorry, everyone, we just need to resolve tech issues for anyone who's got a problem. Not sure how to do that. Okay. So our office will give you, uh, will be in contact and try to help you resolve this issue. But in the meantime, okay, well, so just let me know if there's still an issue that arises shortly, but I'll just need to continue so that we can go through the content. Okay. Um, so as mentioned, we just talking about the structure of the application process, so sponsorship, nomination, and visa for the 482, or and just the nomination and visa for the 186. So other features, the sponsor must not be barred due to adverse information. That adverse information applies to each of the different applications. So adverse information is where sponsor has been found guilty or liable of certain offences against the Commonwealth law, if they've had any sponsorship breaches, if they've become insolvent, if they have provided false or misleading information to the department, then adverse information applies across all the sponsorship frameworks. So visa applications, similarly, you can't be barred from making a visa application. So a bar, the most common bar for visa applications in order to apply onshore will be the Section 48 bar, which is where if a visa has been refused and the visa applicant's not holding a substantive visa and the most recent visa was refused, then visa applicants cannot make a valid application for a visa while they're onshore. They can go offshore, but they won't be able to make it onshore. The exception to that is a subclass 494 because that there's a standing waiver for Section 48 bar. So such applicants, assuming that they have a sponsor who's lodged a nomination under the subclass 494, they can still lodge even though they're Section 48 barred. But for the 482 and the 186, then the visa applicant will need to find a way to go offshore to apply. Okay, I've got a question. Can we apply for BBB and then when they return to Australia for this offshore application? Yeah, so that's a very common way to go about it, which is to apply for a BBB, return back onshore, and then try and do the sort of BBB switch. It's not so such an assured thing anymore because what the department seems to have done is they seem to have cottoned on to the fact that this is a strategy to um, obtain a BVB, go offshore, come back, and then link the new BVB to uh, the application that was made offshore. So they have been granting BVBs for longer periods. So we've seen BVBs granted for periods up to 2 years, 5 years or so. So that kind of removes the premise for the second BVB application to be made because if you're trying to put forward that it's for the purpose of travel, well, essentially the first BVB that was made, assuming that that refused application is at the tribunal, um, that BVB, if that was granted for a longer, quite an extended period, then it's more difficult to substantiate why the second BVB is required. So just be mindful that it's not going to, that's something that you might just need to tell the client, which is that it's not going to be an assured way to ensure that you can get a BVB linked to the offshore application. But of course, they can return after having lodged offshore, and then maybe that application could be processed and could be successful, in which case that resolves the issue. But being able to switch onto the second application with a BVB is not really assured anymore. Okay. So Section 48, occupations must be nominated in accordance with the eligible list. Sorry, if just let me know if there's any sound issues anymore, and I'll remove the mic. But for the time being, I'll just plug this here so I can use my hands. So if that's the case, does that mean you can withdraw the first onshore application as the BVB is linked to it? You could, but it's still risky because there's no assurance that your BVB, if let's say, okay, I guess the scenario would be, let's say you had a visa application refused, maybe a student visa or some other application, and then that's at the tribunal, and then now the applicant has a sponsor and they want to apply for a 482, and then they get the BVB for the student visa, go offshore and apply for the 482 and then return. If you withdraw the student visa, I suppose that's a separate premise to apply for a BVB under the 482, except that there's no assurance that the department will process that BVB in the time frame within the withdrawal period, because when you withdraw an application, then you've got 35 days from that time to hold the visa, to hold the bridging visa. But if the department, the processing times are entirely at the discretion of the department. So if the BVB no longer is in effect by the time the department still hasn't processed it, then you client's stuck. They just become unlawful. Okay, so it's a risky endeavor. I mean, we'd have a look at the BVB, the length that the BVB was granted for the purposes of the initial travel overseas. And if it's a very lengthy period, then we just advise the client, look, we'll probably preempt that by saying that it could be a very lengthy period, and then we'd have to advise the client. It's we'd just have to see how the offshore application goes, but it'll be riskier to apply for a new BVB. Okay. Does that make sense? Okay. So let's move on. Occupations must be nominated in accordance with an eligible occupation list. So each of these have a different occupation list. May as well write it out. The occupation list for the 482 and the 186 is now called the core skills list. So that's, well, there's a separate stream to the 482 as well, which is the essential skills list. But the core skills list is contained within LIN 24/089. For the 186, it's LIN 24093. So the core skills list are identical between the 482 and the 186 for direct entry. And then the 494 is 19, I think, 219. So the 494 probably has the most expanded list. It's got the it's got a whole number of occupations that covered the previously known medium to long-term list and also the regional occupation list, and that covers something upwards of 400 occupations. So that's the most expanded list that we have. The core skills list under the 482 and the 186 are identical, as mentioned. The TRT, so just to explain some differences, however, the 482 also has a specialist skills list, specialist skills occupation, which is if the nominee's been offered a salary of, I think this current rate is 141,210 or 120, 210, let's say, to be safe, over 141,000-ish salary, and then the occupation is on ANSCO major groups 1, 2, 4, 5, and 6, I think, not any of the trades under major group 3, then they don't have to go under this list, but they just have to be under one of those. So that's sort of salary benched. And then the 186, that occupation list, the core skills list, is just for direct entry. If there is a transition from someone who holds a 482, they can hold the 482 and work on the 482 for 2 years, and then there's a temporary residence transition stream to go from the 482 to the 186. So that doesn't need a list. Okay. All right. So occupation lists, each of the subclasses require particular standards of skills to be shown. So particular qualifications, particular amounts of work experience. So for the 482, so each of them requires at least a minimum standard under ANSCO. So that's in addition to, well, in addition to the fact that you need 1 year of full-time work experience in the last 5 years for 482, and also for the 186 and the 494, then there's a skills assessment and 3-year skilled work requirement in addition. But when I say in addition to, I don't mean that the 1 year is on top of ANSCO. It just means that not only do they need 1 year of work experience, they also need to meet the minimum requirements under ANSCO. So if ANSCO says that you need a bachelor's degree as part of a skill level 1 occupation, then you need to have that bachelor's degree, or otherwise the substitute of 5-year experience. And then on top of the bachelor degree, you need to show at least 1 year of work experience for the 482. So can you clarify an RPL-based study? So in order to get, I suppose, is your question relating to meeting a particular qualification? So if an applicant has completed a degree of work experience and they want to get recognized prior learning units based on that work experience, and they get awarded a particular qualification, then that's, so instead of studying, let's say they've worked and then they're able to demonstrate to the RPL, the education provider, that they've got the necessary skills to match the units. Then if they cover the full range or sufficient numbers of units for a particular qualification, then they will get the certificate 3 or certificate 4 or diploma or whatever it is under the RPL. And then that could, I mean, there's no necessity under ANSCO that it needs to have been through study only. I mean, if it's a qualification through RPL, then it could also be accepted, I assume. If an applicant has 3 years full-time work experience and obtain RPL, say Cert 4, will this meet the 482 skill and experience requirement? I would think that it would, because it meets the criteria, firstly, that it's 1 year of full-time work experience. It doesn't say, another thing to note is that for the 482, it just has to be 12 months of full-time work experience. It doesn't say that it has to be at the skill level of the occupation, such as for the 186 and the 494. Okay, so for the 482, any amount of work experience, even if it was going towards, they'd never done any kind of cookery before, but they then just picked it up and then um, completed 3 years of it. And then if they managed to get Cert 4 in currently kitchen management through RPL, then they should, I would say that that qualifies because as long as they've been working for at least 12 months, and they also have the Cert 4, which is according to ANSCO, there's nothing more in addition to the Cert 4. So it's either Cert 3 plus 2 years on the job training or a Cert 4, which should cover the amount. So I would definitely look at making that argument. So yeah, yeah. I would say because the requirement under the Schedule 2 for 482 is that firstly you meet the skills and qualifications for the occupation, which under ANSCO is just a Cert 4 with nothing extra. Um, or alternatively 3 years work experience. Okay. But the 482 also requires a minimum of 12 months full-time work experience. The work experience doesn't have to be at the skill level of the occupation, in which case it might be that there might be a bit more of a uh, you know debate whether how much of that was at the skill level required. But because they've both got the qualification and have worked at least 12 months full time in the role, then I'd say that that meets both the requirements of 482. So I'd be pretty confident about that. Um, so for whether RPL is accepted for 186 or just for the 482. So with the 186, I'd be a bit more cautious about it because 186 requires 3 years work experience at the level of skill required for the occupation. So whether or not there would have been a particular carve out of that 3 years work experience that was required in order to get the person skilled, um, that that's a question. And for the 186, you also need a skills assessment. So that generally that will invariably result in a probably like a carve out of a particular of a particular portion of the work experience as well. So, okay, so got a question. So sequence of experience and qualifications is not important. So the sequence, yeah. So yeah, certainly for the purposes of a sponsored visa, particularly 482, which doesn't require the level of skill shown in the experience, then it doesn't really matter if they've just jumped right into the work experience rather than get a qualification first. But then they get an RPL, which proves that they're at a Cert 4 level if all of their skills have been benched against Cert 4 units and they meet that requirement. Then that would be sufficient to meet, I think, the statutory requirements for skills and qualifications. In summary, as long as they hold the required qualification, e.g. bachelor's, and have been working for 1 year full-time or 2 years part-time during study, then they meet the 482 skill and experience requirement. Yes, I think that the current regulations in relation to the 482 supports that interpretation because if they needed to be at the level at the skilled level required, then they would say it, such as in the 186 and the 494. And I would argue that because they don't make that distinction, because they have, it is different. The wording for the 482 legislation is different from that of the 486 or of the 186 and the 494. Then I would argue that whatever period of even like the occupational work that's even below the particular level of or along the way to getting the qualification by RPL would count. Yeah, that's right. Experience doesn't need to be in the particular skill level. It can't be too far off. I mean, it can't just be like a kitchen hand is not going to be counted. It still has to be along the pathway of of the qualification. And with the 186 direct entry, does work experience have to always be post qualification? Yeah, I would say so. And in fact, to take a more conservative view, if people have ever gotten skill assessments through VetAssess, then you'll note that often they'll carve out a particular period of even post qualification work experience and say that this is what was required in order to become skilled, and therefore we only count the experience after that. I mean, there's an argument that it should be benched against ANSCO, and I think there is policy to support uh, to support that, which is that it's it's skilled per what's required under ANSCO. So if it was a qualification, then any post-qualification experience ought to be counted as being skilled, and we shouldn't rely just what's dictated to us by VetAssess regarding that. But definitely post-qualification, I would say, to be safe about that. I know 186 is similar to GSM when claiming points, i.e. experience at the skilled level is after being properly skilled and qualified. Yeah, so that's the argument that I would put forward. As in, there's department policy suggests that they don't necessarily have to rely on what the VetAssess or whatever skills assessing authority dictates as only after this point you're skilled. They just take the more beneficial view, whatever that may be. So that could be ANSCO could be the more beneficial, you know, the beneficial assessment to be assessed against. But post qualification is generally what we would take. Though 3 years of experience in obtaining RPL, would this satisfy 186 direct entry? So I would be cautious about that. So if they don't have a prior qualification and they've only obtained that 3 years and gotten an RPL qualification on that, then the question is, if they've started from from like nil, then how many of those 3 years was it at the skill level required? Because there's a specific word in the in Schedule 2 for the 186 saying it has to be at the skill level required for the occupation. And if they're just sitting on 3 years from nothing, from no qualification, no prior experience, then I'd be quite wary about saying that that will meet 186 direct entry requirements. So again, there's a difference between the 482 and the 186 and the 494 for that matter. Okay, so you just have to, I wouldn't recommend a 186 for someone who has no qualifications prior, but just started from nothing and did 3 years of work experience, got an RPL for the qualification. I'd say that's a bit risky to go for. Probably safer to just go for 482 and then move that to the 186 later on. Okay, good. So skill level requirements. So all subclasses need to show market rates. Market rates being that it has to be both at the threshold, but also that the market rate has to be above the threshold. Okay, so talk a bit more about that later. The position has to be genuine, so that applies to each of the requirements as well. Each subclass allows members of family unit to be included as dependents. So essentially partners and children can be included. And there's a separate labor agreement stream, which is separate from the standard business sponsorship and just the standard streams. That's for situations where maybe the occupation is not on the list, or the visa applicant requires a certain degree of concessions. Maybe their English is insufficient, or they're over the age. The age for 186 is 45. So if they're over the age, and they'll need a concession through a labour agreement, or they don't have the skill requirements, then that's all considered through a labour agreement, assuming that they can establish one with the department. So there's certain distinguishing features of each of the subclasses. As mentioned, the 482 is a temporary visa. The 186 is a permanent visa, and then the 494 is a provisional visa. provisional means that, generally speaking, the 191 after 3 years open to the 494. So it's expected that someone on the 494 will move towards the 191, assuming that they just meet all the visa conditions. Okay. So 494 allows regional sponsorship only. Regional areas are defined as being just essentially outside of Melbourne, Sydney, or Brisbane metropolitan areas. The particular postcodes are set out under instrument LIN 22/022. They'll be on a later slide, but just mentioning that for now. So the 186 and 494 require valid skill assessment, subject to limited exceptions for, I think, just for academic applicants and 444 holders. Whereas the 482 generally doesn't require skill assessment, but there are certain occupations and coming from particular countries which require skills assessments, and that's primarily certain trades in the category 3 ANSCO occupation grouping, but also program administrator and specialist managers not elsewhere classified. Labour market testing is required for the 482 and for the 494. There are certain exemptions for the 482, particularly coming from agreements, international trade agreements that Australia has with particular countries. The 494, there's no exemption. So anyone pursuing the 494 requires labour market testing to be done. We've talked about Section 48 barred applicants already. So 494 is the exemption to that. Talked about different standards of work experience, different standards of English. So 186 and the 494 generally require competent English, which is the equivalent of 6.0 in each band of IELTS. But in the instrument itself, so aside from IELTS, recent changes to the English language testing criteria provides a range of English test providers, but the scores are also quite different now. So there's different scores in each of the bands for most of them, except for IELTS. So IELTS is probably just the simplest way to proceed with. The 482 requires 5.0 in each band of IELTS or equivalent. With the 482, you can lodge a visa application after skills assessment was applied for and not yet finalised, but with 494 and skill assessment must have been finalised. Yeah, so for the 482, assuming it's a mandatory requirement for a skills assessment, and you'll be able to check where it's mandatory under, I think the instrument should be IMI 18/038 or thereabouts, 038, 039, but 18/038. Those particular occupations and coming from particular countries, where the nominees come from particular countries, then they need to commence a SID or previously TSS skills assessment in order to lodge a valid application. But yes, with the 186 and the 494, the skills assessment has to be finalised in order to lodge the application. So yeah, the instrument that I've put on the slide has to be changed. Sorry, that needs to be adjusted. So the instrument for the 186 and for the 494 to meet competent English is, I think, LIN 25/016, and the one for the 482 should be 25/082. But if it's not in the slides or if it's not in the workbook, I'll update that later. And we talked about different occupational lists for each scenario. Okay, so just a bit of a summary of some changes that have come about in the last 2 years. So since 1st of July 2024, there was changes to the work conditions, 8107, 8607. So that's the work condition for applying to the 482s and 494s, that they have to work, the nominee has to work only with the approved sponsor. I think the major change was just that they have now 180 days to move from one sponsor to another at the point in time that they ceased working. It's not finalized. Okay. Can you reconfirm during 180 days they can work in any occupation? Yeah, so there's no limits in the 180-day period that they've ceased working with a previous sponsor, and that can include maybe with a new sponsor or someone who's they're moving towards sponsoring them. Of course, if it's approaching the end of the 180 days, then for the sponsors' compliance purposes, they should cease letting the nominee work unless they've been approved a nomination for for whatever they've nominated. If it's approaching the end of the 180 days, we would push the department to finalize the application sooner so that they won't be in non-compliance. But yeah, during that 180 days, there's no limit to what they can do. Okay, so since October 2024, then secondary applicants only for the permanent visa, so the 186, can access family violence pathway provisions if they've suffered family violence at the hands of the primary applicant, or there's been the primary applicant either has been approved or in the alternative been refused a visa for the reason of having committed family violence or been found to have committed family violence. Then they can the secondary applicants can access family violence provisions. Okay, and then some concessions for children born in Australia to meet the health requirements. So just some other changes. I mean, these have all been covered, just been summarized here. Core skills list, specialist skills list, talked about that earlier. So those are changes. Those we've got different. So those were just the changes as of December 2024. Obviously, some of the figures here have been indexed as well. So it's no longer 135,000 for specialist skills stream. It's 141, 210 or thereabouts. And the application fee for the 482 is increased to 3,200. And so that's just summary of requirements. I think that's also just summary. Fair work, high income. Okay, so that's for the current year. Core skills stream threshold and market rates have to exceed that amount, 76,515. Special skills stream threshold has to exceed 141,210. Fair work, high income threshold. Fair work, high income threshold is relevant for applicants over 45 who are looking to transition towards 186. So the concession for applicants over 45 is if you've been paid the Fair Work High Income threshold for at least the previous 2 years as it applies in that particular year. So it has to obviously scale or ideally be much higher above that Fair Work High Income threshold. So English, there's been changes to the English. So there we go. English language testing. Okay, so we'll go into a bit more depth about each of the particular application streams. Sponsorship criteria is generally fairly straightforward. The main thing is that the sponsor needs to be lawfully and actively operating and that there's no adverse information. I mean, the commitment to employing local labour testing and local labour market non-discriminatory recruitment practices generally accepted as that is met unless there's information to the contrary. So there's provision for sponsors to be accredited. So if they're accredited, then they usually get a faster they can usually expect faster processing. Sometimes, approval upon lodgement is can be quite common, but in general, they get prioritized. Um, Put there on the slide just the requirements to actually meet accreditation categories. So obviously, Commonwealth government agencies will get that accreditation. Australian Trusted Traders. So Australian Trusted Traders is a specific status of companies. They uh, will have a certificate stating they're a trusted trader if they are one. Low volume, high usage of percentage. So if there's not been a lot of applications lodged, then the sponsor needs to have at least 85% of Australian workers not have any nominations refused, and also need to show a particular revenue threshold, which is 4 million in the past 2 years, in addition to all the other requirements. So high usage, then the percentage of Australian workers can be a bit less, 75%, still quite high, but can be a bit less. And the major investment in Australia category is quite rare because you have to invest 50 million in Australia directly in order to access someone. So further to Raymond's question, can you include a skills assessment unsuccessful outcome in the appeal to ART when you appeal and refuse a visa application that was refused for not having a positive skill assessment? Okay, are we just talking about the 482? Because for the 482, obviously for the 186, you can't lodge unless you've got a positive skill assessment. For 482, if it was refused and the skill assessment was refused, it's still, so for the purpose of making a valid application, you need to have applied for the skill assessment. And then for the purposes of meeting the time of decision criteria, it's that that there is a valid skill assessment at that time. So you can appeal to the ART because it's time of decision criteria to get a positive skills assessment. And whether that's achieved through internal appeal processes, an internal appeal process through the TRA, presumably, or just by a subsequent skill assessment, I think both are fine. So skill assessment, so yeah, so we're just talking about the 482 here, correct? So English is also time of decision for the 482. Again, for the 186 and 494, they're all time of application. Like you have to have those scores at time of application. But for the 482, because they're time of decision, yeah, you can provide updated English test, and oftentimes that's a fast track way to resolve the tribunal. So if it's just an English test or just a skill assessment, then if that's achieved as at the time that the tribunal assesses the application, or you could ask for it to be expedited. If it's accomplished, then the tribunal can remit it back. So yeah, they're all time of decision. Another thing to note with the 482 is for the English test instrument that prescribed the score also allow for a one score reset. So one skill retake. Thank you. So that means that the applicant can actually just do a retake of a particular score, and then they can use that for the purposes of the English, the language testing. The 186 and 494, I don't think that instrument supports a one skill retake. So you need to get that score in a single round for that. One skill retake only for 482. Yeah, that's our position. Where is the accreditation categories information coming from, please? A specific policy? It's department website. So they don't, yeah, there's no regulation about it. You just have to search it up on the internet. Accredited sponsor, accreditation sponsor. It's on the department website. All right. So adverse information. Um, adverse information applies to all sponsorship categories, and it's so there is a provision for it to be disregarded, assuming that um, the the whatever breach or whatever adverse information might have happened a long time ago and it's been rectified, or it wasn't very serious, it wasn't repeated, or it wasn't like there wasn't a pattern of misconduct. There is a very expansive scope of associated with. So that includes family members, friends and acquaintances, consultants, advisors, employers, employees. A lot of people are covered if the sponsor has any link to any of those individuals or companies that have uh, adverse information. Of course, the more tenuous and more distant the link, then the less likely it will be that it's not reasonable to disregard, because that's hence the reasonable to disregard criteria. So obviously the standing policy is try to disclose, uh, like err on the side of disclosure rather than not, but address the reasonable to disregard criteria for adverse information. If there's any sort of notifiable events, and you contact the department, and if the applicant can't lodge online, then there's a facility for manual lodgement. So nomination criteria, kind of already covered some of this, but also the SAF levy is paid for at the nomination stage. So SAF levy for the 482 is scales by the number of years requested. So if it's 1 year, 2 year, 3 year, 4 years, it's 1,200 for any sponsor with a revenue under 10 million, or 1,800 per year for any sponsor with revenue of over 10 million. And that's all paid at the nomination stage. Certain occupations have particular caveats, usually relating to revenue, revenue thresholds, number of employees, certain occupation-specific caveats, such as that it's not in a particular low-skilled or a very sort of like standardized production kind of business. Okay, labor market testing. So have to for the 482 and the 494. Generally, there's an expectation to advertise for the role. So the standing requirement is essentially 4 weeks on 2 job platforms, and these platforms need to be platforms that are accessible nationally. So we've observed or heard about issues coming from people using LinkedIn or particular marketplaces, where while there is a job recruitment or job ad publishing aspect, it's not considered a recruitment site, because the primary purpose of it isn't to advertise for job listings. So for that reason, it's safer to use the more typical job sites such as Seek, Indeed, Career One, Adzuna. I'd steer away from LinkedIn, because we have seen some decisions that weren't great for LinkedIn. Okay, and then secondary applicants identify genuine full-time positions. So the key aspect of a genuine position is that the position has to fall within the scope and scale. It has to make sense within the scope of the company. But there is also, at least recently, we've seen a lot more decisions that hinge on whether the department suspects that the application is just for a migration, to secure a migration outcome. So migration outcome, if they feel like, if the department feels like it's more that they're trying to assist someone get a visa, as opposed to filling a genuine skills shortage, then that could be a reason to say that it's not a genuine position. How about work initiatives that does the LMT for you? Do you recommend it? We don't recommend. I mean, there are certain services that conduct LMT, and they swear that they get, the scene. They swear that they get very high rates of success. Um, it's having reviewed some of them. I don't, we're not particularly comfortable using those um, services. I mean, usually we work more with the client and tell them this is what you need to do in order to advertise, for the position. Not to say that, I wouldn't say that it, if you sort of, need it in a pinch, that they won't assist with the LMT. It's just that having reviewed some of the reports that come out, I do have some concerns about them. But the department requirements are essentially that it has to be, there's statutory requirements. So they have to have certain information in the job ads, and they have to meet certain metrics. And if it doesn't meet those metrics, then that's grounds for refusal. So of course it's riskier if you're just asking the client to do it and on their own, and if one or more of their features aren't there in the LMT, then that risks a refusal. And also the advertising has to be a continuous period, so it has to be a continuous 28-day period. If it's broken up, if they took the ad down and then a few days later put it back up, then departments actually found that that's not the continuous period of advertising, in which case that nomination is basically a write-off. Okay, so it's certainly a process that you need to be quite on top of, but and you might want to just pass on the risk and the stress to an external provider. So yes, there are, but we don't recommend or use them. It's my answer. Okay. Market rates and CSIT. Sorry, some of these terminologies are outdated, but market rates have to exceed both. So both the salary offered to the nominee and the market rates need to exceed the threshold. So labour market testing, okay, as I've just described, it needs to be a particular duration, so at least 4 weeks across a 4-week period. It has to be conducted within the last 4 months. There must be 2 ads, and they must meet all the description. So they have to have the title description of the position, skills and experience required, name of the approved sponsor, and salary to be offered if the salary is less than 96,400. So a select occupation or select position is different from an exemption. They still have to do labour market testing, but in the sense of having to write a document that says why there wasn't any suitable applicants that could be located, but they don't have to do the actual specific job ad statutorily prescribed labour market testing that they did. So just some select position examples. That's just there in the slides. Sorry, just to ensure that we're on track, I'm not going to go through everything in the slides. Everyone can review them in your own time after the fact. So just going to give some context and then we can move on. So labour market testing exemptions, there's certain countries based on the international trade instruments that Australia has, the bilateral relations that Australia has with certain countries, then they will be exempt from labour market testing. So they don't have to show any labour market testing. But you still have to show evidence that that Australia is exempt, or the applicant is exempt, in the sense of maybe having to locate certain texts of the instruments and referring to the department policy, referring to the department website, and showing that the applicant has the relevant passport or has worked the relevant 2 years um, prior to making the application. So I think a good strategy that we use is if we can, we conduct labour market testing. But if there's time to, we always recommend doing labour market testing. But we also claim an exemption if it's there. That way, it's a fallback for the labour market testing. And the benefit of identifying an exemption is that you don't have to put in the numbers. So you don't have to actually put in the numbers of applicants that applied for each job ad. So you can just put in the job ads, the proof of the job ads. But then I think you're sort of hedging your bets, ensuring that one way or another, the applicant is going to be assessed and it's not going to be disqualified if there wasn't an exemption, if it's a bit of a controversial exemption. Okay, so we've covered SAF levies. So the difference for the 186 and the 494 is that it's the 186 and the 494 are fixed, or depending on the revenue, but so 482 scales, the SAF levy scales based on the number of years requested. But because the number of years for the 186 and the 494 are the same, the approval periods are the same, then it's fixed. So there's certain refund provisions. I'm not going to go through those in any detail, but they're all there on the slide. Refund provisions. So talked a bit about the position being genuine. It has to be also, position has to be full-time except when, I mean, the provision is reasonable to disregard, and policy indicates that it's for particular scenarios like medical practitioners, fractional appointments of academics, and really sort of high-ranking CEO or board members. Okay, so a contract of employment must be signed by a sponsor and the nominee, and by extension, in order to comply with condition 8607, they need to work only with the sponsor, except when exempt. So CEOs, general managers, and a full range of medical practitioners are exempt, both from having to have an employment contract with the sponsor, but also being able to work with other sponsors or work with other companies during the time when they're holding the 482. There is a requirement that in order to count the work experience for the 186, the applicant still has to work with an approved sponsor. So for those who are just moving around working with other companies, they have to ensure that they're an approved sponsor in order to count that work experience towards the 186 criteria. So that's just something to be mindful of. So adverse information, mentioned that already. So annual market salary rate, having to show. So in substance, annual market salary rate requirements are first, there's three components to it. So first, the nominee has to be paid above the threshold. Second, the nominee has to be paid at or above the annual market salary rate. So whatever equivalent Australian workers, the nominee must not be paid, assuming they're in equivalent position, they must not be paid less than the Australian equivalent worker, or offered terms no less favorable. And then third, the annual market salary rate has to be above the threshold. So thresholds, if previously I think the department was referring to where there's an award that applies, and the department would often refer to the award and say that's the market salary rate. But in view of a recent amendment, then the sponsor can choose between either the award, if there's no equivalent worker, they can choose between the award or showing it through independent proofs such as job ads, salary surveys. If there is a equivalent worker, then they have to show either the award or the rates of the equivalent worker, and that they're above the threshold and the salary rate is above the threshold. Okay. So just talking about the occupation lists here, got these have all been mentioned, but sorry, these need to be updated as well. No, they're correct. Actually, so you can, yeah, just have to go through the occupation list. If there are any caveats, then make sure that that's met. So it's just a range of commentary on the occupation list. You can analyze that in your own time. So, all right. So visa applications. We've mentioned some of this before, and I think we've covered a lot of the um, skill and work experience requirements earlier. In addition, there needs to be a range of common criteria, such as meeting public interest criteria. So public interest criteria usually relates to health, character, and ensuring that there's no false or misleading information made. So PIC 4020 applies to all the subclasses. Special return criteria, if anyone's ever been, if the applicant's been removed or deported from Australia, they won't, or if they've had their visa cancelled on a character, Section 501 character, then they can't ever return to Australia. If they're in Australia, obviously that's no special return criteria will apply. They're medical practitioners. They need to meet the relevant registration requirements. And then English and then health insurance. It's all set there. So we've mentioned the occupations and the mandatory occupations. So 18039. Okay. That's the instrument that sets the mandatory occupations coming from particular countries that require at least the commencement of a skills assessment through a TRA usually, or through a TRA prescribed provider. So applicants who apply onshore must hold either substantive visa or a bridging visa A, B, or C. So if they're unlawful, or if they're holding a bridging visa E, then they can't apply onshore for the 482. And that also applies for the 186 and the 494 for that matter. All applicants must either hold a substantive visa or a bridging visa A, B, or C. Okay. Then we've mentioned the 1 year full-time work experience, in addition to actually meeting the criteria under ANSCO. So it's the English test, which we've talked about earlier. So for those, for applications that were for English tests taken before the 13th of September 2025, they're still in accordance with the old, it's in accordance with the old list, with the old requirements, as long as it was made in the 3 years prior to making the visa application. But for English tests taken on or after 13th September 2025, then the score has to match whatever is in the new, instrument. There's now a range of additional providers as well. So there's a Canadian provider, CEL PIP. There's the Michigan test provider, MET, language cert. The key main additional providers it's worth trying and seeing if it's providing a better outcome for applicants. So there are exemptions to English if they're from one of the deemed English-speaking countries, UK, US, New Zealand, Canada, Ireland, or if they've completed a particular degree of formative schooling, or they meet the English requirements for mandatory licensing and registration, or nominated by an associated entity where the salary is above 96,400. So a visa application can only be linked to a single nomination, which means that if the nomination was refused, then the visa application must be refused or withdrawn. You can't just lodge a new nomination and then ask for the visa to be linked to that nomination. On the flip side, though, a nomination you can link different visa applications to the same nomination. So if a visa application, so obviously for that reason, if a nomination, as long as the nomination has remained valid, then that could be a ground to, if there is a nomination approval, then maybe a relodgement is possible of the visa application if it was refused for a reason, rather than having to go to the tribunal, assuming that they're not Section 48 barred. But you can't, if the nomination is refused, that's when the visa applicant is stuck, unless the nomination is also at the tribunal, and then the visa application has to go through the tribunal. So health criteria, there is a waiver, which is if there's certain costs that the deemed costs of an applicant is above a particular threshold, then the waiver could relate to whether or not there is, grounds for mitigation or other compelling circumstances. Provisional, yes, provisional licenses that allow practice are generally accepted. That probably applies for certain occupations, particular medical occupations. I think that they accept that. Architecture, because architecture licenses are notoriously difficult to get, then a provisional or just a lower level license from just full architect allows the applicant to still be approved and continue to practice. As long as the registration or licensing, if it's mandatory, that is, so if it's mandatory, but it allows them to conduct the full scope of their role, whether under, loose management or supervision, as long as they can conduct the full scope of the role as described under ANSCODE to the skill level required under ANSCODE, then that form of license would be acceptable. Okay. Or it could just be if you're just working towards or able to obtain the license. So for someone who's overseas or hasn't started the job, the license, as long as they're eligible for the license, that could be, that would meet the criteria for approval. And also you have to check if the license is mandatory, because sometimes licenses aren't mandatory. In the accounting space, for instance, accountants don't necessarily need a license, but tax accountants need some form of licensing or registration. So it depends on the occupation, and similarly, certain engineering professions need licenses, but others don't. But it just depends, and that is determined on the basis of independent information. There's different regulatory authorities that oversee the licensing registration regime for different occupations. Okay. All right. So we've got a bit of time. I figured what we'll do is just running through a sample IMI account application, just to get a sense of how the criteria matches the particular question, how in practice, application would match particular criteria to be assessed. So we'll just go, it sounds like people are generally on top of applications. Most people seem to have done an application. So we'll just run through this quickly. If there's any points of note, I'll raise them. But the idea is to get through it quickly and get through the other content as well. So the first sort of question in relation to sponsorship is what stream we're going for, whether if it's a labour agreement stream, you'd assess that, or actually, there's a separate labor agreement application process under the IMI account. So you wouldn't use standard business sponsorship application if you're applying for a labor agreement. Okay, so this is just for standard business sponsorship. But you put in any of the details of the company. I think that's mainly to ensure that the company is lawfully operating. So obviously they'll double check with ABN and ASIC, and if there is evidence that the company is in external administration, then that would be grounds to trigger a natural justice letter asking what the status of the company is, and whether it's insolvent, because obviously an insolvent company cannot lodge an application. It's not lawfully and actively operating. Um, so just some information about, so point to note, there's no minimum amount of time that a company needs to operate in order to lodge sponsorship. It just has to be lawfully and actively operating. It doesn't have to trade. It doesn't necessarily have to be in a position where it's trading. So as long as it's activity, like say a company has just started a few months ago and there's evidence of bank accounts opened, all the registrations, with ASIC done, bank accounts are opened, and expenses can be seen, correspondences about renovation and all that. Such a company can sponsor. They're lawfully and actively operating. Obviously, the challenge will be whether or not at the nomination stage, if it's just been a fairly recent company opened, established, whether or not there's a genuine position available, whether there's financial capacity to cover the position, if there's no evidence of trading income, or if the trading income is very low, or there's not a lot of employees, or if it's operating at a huge deficit to begin with, then that could be questioned at the department stage. It's not uncommon for startups to be refused at the department, and then later on, if it's appealed at the tribunal later on, maybe there is significant more proofs that the company has traded, established a rhythm of sort of trading lawfully and profitably, and then the nominee is also working there. So that's might be good proof of genuine position. But the key point being that there's no necessarily minimum period that's required in order to establish lawful active trading. Okay. The web pages, if the company has a web page, the department may just look at it and just see what the scope of operations are, what kind of or if it's active, but that's all part of that aspect. So identifying all the owners and directors. So there will be for standard business sponsors, if additional directors are added later on, there's a obligation to report additional owners and directors. It's primarily, I think, to deal with whether or not adverse information issues need to be addressed, because a new director may have their own issues with adverse information, and then that by association under Reg 1.13b, that causes a company to have a disclosable adverse information event. So all the initial owners and directors need to be identified, but also upcoming or future directors, if they become one, have to be disclosed to the department as part of the sponsorship obligations as well. Okay, so the department wants to know turnover and payroll. It's again that will be directed towards assessing the nomination aspect of the genuine position, whether or not the company has the scope and scale. So both scope and scale of operations. If the nominee's payroll, if the salary offered to the nominee is taking up a significant portion of the total payroll, then that'll be scrutinized. It's not necessarily disqualifying them, but you need to, you'd expect to maybe have to explain it, or the department may I mean, sometimes they won't even give you the opportunity. They'll just say that they're not satisfied that there's a genuine position based on the information provided, but they may ask questions about, look, your payroll is, 200,000 and the nominee, you've offered the nominee 150,000. How are you going to pay their salary? And is it, a legitimate position? So all of this has relevance in the overall assessment. Okay, so adverse information question, you provide their information. There's a question about just reasons, explanation for how there's going to be less reliance on sponsorship framework in the future. I mean, we have a pretty generic answer there. And usually that's okay. I don't think that much more is requested or required from the department, aside from just saying that, it's being used sparingly. We're training locals, we're attempting to undertake LMT to get local candidates, but when we need it to meet a skill shortage, then we'll rely on the overseas candidates. Okay, so again, in terms of numbers of employees that would, at the sponsorship stage, that's not significant, but if the numbers are very widely divergent at the nomination stage, then that may be looked into, and also just to establish whether that is consistent with payroll. So if you've identified 10 employees and the payroll is 200, 300,000, then the department, I mean, we've seen decisions that say the department referring to such things and saying that doesn't make sense. How do you have 10 full-time workers if they don't clarify who's full-time, who's not full-time? How do you have 10 workers having this kind of salary rate? Suggests that they're not, there's like something that's been hidden from the department regarding the full scope of the operations, and then we're not satisfied. So the thing with the department is that they can be a bit lazy. Like it's within their power to be lazy. They don't need to seek an explanation for certain questions that they have. They can just say, I'm not satisfied, right? This raises suspicions, I'm not satisfied. So to establish, if there are questions, of course, this is also a strategic and situational thing. Like you have to decide is it better to disclose more or disclose less. But if there's certain aspects of the application that you feel like probably is going to look suspicious, then you might want to jump on the front foot and explain. So if there is a huge discrepancy between number of employees and the payroll figure, then that's something that you might want to check with the employer. Firstly, like, can you explain what this payroll comprises of, or can I have an org chart, and so that we can just be on the front foot and explain to the department so that they don't have that suspicion, or that suspicion has been assuaged. Okay, because again, while the department may send you a Section 56 notice or a request for further information, they can also just finalize just on the basis of the evidence available and just say, I'm not satisfied. And then you have to go all the way to the tribunal, and it's a waste of time and money. Okay, so just a page regarding sponsorship accreditation. So that should track with the department website about what each of the categories are. That's still the same. And then that's all fine. So just a list of obviously all the attachments that can be provided. Just checking if there's any questions I haven't answered. Okay, so nomination. So after the sponsorship application, it just has to be lodged. It doesn't necessarily need to be approved, but if you'd want to lodge the nomination and visa shortly after the sponsorship, because if it's refused, then you have to do it again. You can't lodge a nomination when there's against a refused sponsorship, not even if it's on appeal. So a nomination has to link to sponsorship. You put in salary of the applicant, where they're working, identify. So just extract about occupational caveats. So in this case scenario, we're going for the nomination of cook. So you have to check in the instrument 24089 whether there's any occupational caveats that apply. So the occupational caveats for cook are that, firstly, the position is not involved in mass production in a factory setting, and also the position is in a limited service, is not. So reading it is a bit complicated. You kind of have to, because these are disqualifiers, you kind of have to do the negative of that. So you have to do the inverse of what's there to meet the requirement. So you have to read it like caveat 3 is that the position is not involved in mass production in a factory setting. And then caveat 4 is the position is not in a limited service restaurant. Limited service restaurant fills a range of so this is also under the instrument. This is all a definition, a legal definition. So fast food, takeaway food service, fast casual restaurant, drinking establishment that doesn't offer much food service. So pubs and bars can sponsor. They just have to have a full menu, like a full sit-down menu. Just because they're a pub doesn't mean that they can't sponsor. It's only if they have a very limited menu, like just range of mixed nuts offered, then they won't be able to sponsor. So it still has to focus on food. So for a cook occupation, there has to be a significant food component. So limited service cafe, including coffee shop or more cafe, limited service pizza restaurant. So that's, I mean, in practice, you have to analyze the scope of the restaurant in a bit more detail. So, and there's certain words there that can be sort of engaged with. So fast casual restaurant, department policy seems to indicate that even if the food is of good quality and there is sort of like made from raw ingredients, it can still be a fast casual restaurant if it's if a lot of the other features are there. So for instance, limited sort of no table service, limited standardized menu. Franchises suffer a lot from this because with franchises, there's no scope for variation or very limited scope for variation of the menu. So it's like considered very standardized. So that makes it a bit more difficult. But then again, on the flip side, just because the restaurant is a particular form of restaurant that's mentioned, so let's say it's a pizza restaurant that sells pizza, doesn't mean that it's a limited service pizza restaurant either. So it could have an expanded menu. The pizza could be higher quality or a bit more of a gourmet style. It could be an evolving menu. So those kinds of things will be all sort of for submissions to argue that it's more than just what the caveat indicates. Because there are no caveats for the 494, can a fast food restaurant in a regional area nominate a cook? Well, you still have to be careful because if they can't get you on the caveats, they may get you on the occupation, right? So cook, there's a list for cook, but there's also lower level occupations like short order cook. So obviously, if it's a restaurant where the cook, the sort of the expected degree of preparation is going to be limited, then that may be a issue for someone just nominating. So that's what the department used to do before before these caveats came about. They just resolved it at the and if it's a known fast food restaurant, like if you're just talking McDonald's or KFC or somewhere, then I wouldn't really be hopeful because then again, the nomination of the occupation itself the position offered is unlikely to meet the standards of the ANSCO code. But obviously, if it's a franchise where there's a bit more prep work involved, then I don't want to provide any assurances for any franchises, so I'm not going to name any names. But if it's going to be some kind of establishment where the person is just preparing from raw ingredients, uh, and from and they're preparing the meals ad hoc and has accounts for various dietary requirements, cooking from particular menus, then that's more arguable. What about catering? Yes, well, we just have to be careful that that's not a mass production in a factory setting or fast. So not in the. So we just have to abide by the caveat, but also just by the occupational criteria. So it depends on the degree of catering as well from the company. I don't think that an establishment that just caters is necessarily disqualified from being able to nominate. It's just that if most of the catering is just a bunch of sandwiches or like just bulk sandwich production or something that has lower level skills, then it might, if not necessarily disqualified by caveat, it might be disqualified by the position or the occupation itself, as in the occupation may be considered to be not a cook, okay, because there's lower level cooks, line cooks, short order cooks. They're not considered cooks, or just food and beverage attendants, and then that is the issue that might arise. And of course, with these applications, then the department can always do integrity checks. They can check the website. They can check what's publicly promoted about the company and what they offer. So you have to be prepared. The department's going to do their own verification checks. They don't have to provide any of whatever the department finds online. I mean, it's open for them to not necessarily to put it to the applicant for further comment. So these are questions that you need to ask your client and just be on top of. Okay, so annual turnover, they're going to ask some of these questions again, like number of employees, turnover, degree of turnover, because nomination can, things might have changed between the time of sponsorship and time of nomination. So you need to be aware of how the company, your client company, has evolved over time. Okay, so just putting in the details of the position itself. Always want to put in at least the minimum for a particular position. So whatever is prescribed under ANS code, it's ideal to say that the position requires this amount of qualification or experience. And again, updated staffing numbers, market rates, whether there are market rates of equivalent workers or not. And then just so labour market testing. This is where you have to put information about labour market testing in. Then brief explanation for why there weren't sufficient. I mean, the labour market testing can still account for the fact that to respond to labour market testing, you can have your own independent report as well, and provide a bit more of an expanded explanation. It's not necessarily critical to meet labour market testing requirements to have to go through each candidate to provide a response for each candidate and why they're not suitable. Sometimes a summary might be sufficient. I mean, the key thing is that labour market testing is done and it appears from the department to be genuine, but labour market testing isn't just like whether or not it's genuine or not. There isn't a particular provision saying that the labor market testing itself was done genuinely to obtain, like, to seek the labor market, the conditions of the labor market. It's just we've seen decisions where it's, even though labor market testing looked suspicious, it, as long as it was done, it still meets the criteria. As long as it's done in the legally prescribed way, then it still meets the criteria. But it may go towards the assessment of genuine position if it looks like it was low effort and clearly just done to meet labor market testing requirements. Okay, so here you nominate the nominee and any dependents, and then we can proceed to the visa aspect. So maybe this is a good time to have a break, because come back, we'll talk about just the visa criteria and then just the rest of the subclasses. So come back in about 15 minutes and continue. Cue.
Hi everyone, we're just doing a sound check. Can you all hear us? If you can you just type in one in the chat? Thank you.
Okay, hello everyone, welcome back. Let's just get straight into it because there's lots to cover. So, first thing, we're just jumping straight into the visa application side for the 482. And if anyone has any sound or any issues, just pipe up so we can get that resolved right away. Okay. So a cook being a trade occupation is, and a lot of the other trade occupations such as, fitters, carpenters, um, motor mechanics, metal machinists, in that sort of space, hospitality and trade space, may have a mandatory skill assessment requirement for 482 if they're from a particular prescribed country. So cooks and chefs have, I think, the largest number of prescribed countries. So there's about 15 in total. But if they're from that country and they're being nominated in this particular occupation, they have to do a skills assessment or commence a skills assessment in order to um, proceed. Okay. There's certain exemptions. That's just all on the slides. But so just aside from the trade occupations, there's also project and program administrator and specialist manager, not elsewhere classified, that requires skill assessment. I think the reason for that is there was a period of time back in the days of 457 where program project program administrator and specialist managers was generally chosen as the go-to occupation when no other occupations seem to align, or otherwise, if the position is suspiciously like another position that wasn't on any occupation list, and these occupations are a bit more generic, so um, naturally the department gets suspicious, and so they're saying, okay, if you're going to pick these occupations, you better be able to show that you have skills in these occupations. Okay, so those are mandatory except for the exemptions that are highlighted up there. So thought that would just take a little detour from IMI count and just have a look at uh, TRA skill assessment. So there's the skill assessment for the TSS or the SID skill assessment, which I mean, what it encompasses is essentially two pathways. Either they hold an Australian qualification or they don't hold an Australian qualification. If they hold an Australian qualification, then they go down pathway two, which is a generally more accessible pathway. They just require 3 years work experience, and they just need to do, I think, just technical interview, but or possibly not. But pathway one, then that's depending on if it's a licensed trade and depending on if they have a formal qualification, then there's a high degree of work experience that needs to be shown, and then they have to do a technical interview, or in the case of a licensed trade, a um, practical demonstration. So the basically the breakdown is that if they do have a qualification and it's a non-licensed trade, like qualification or formal training, and it's a non-licensed trade, then that's 3 years full-time work experience for someone without an Australian qualification, um, or 5 years if they don't have a qualification. For a licensed trade, it's either 4 years with a qualification or 6 years without a qualification. Licensed trades like, I think, um, plumber, electrician. I'd have to have a look at what the licensed trade are, but mandatory licensing. Oh, electrician. Yeah, just electrician essentially. Um, so pathway two is, yeah, as mentioned, it's if you have a Cert 3 AQF certificate, then you get to go through pathway two. So certain prescribed RTOs. Not sure if that's been updated, but you can check it on the TRA website. There's VetAssess contracts out for certain skill assessments, or TRA contracts out, should I say? It's just a number of number of assessment criteria to be met. So, and then just some fees there. Okay, so short detour. Back onto the IMI account. So we have to put in our client's details, put in any of their specific details. So the number of years they'll get will depend on how much the sponsor has been willing to pay under the SAF levy. Okay, so if it's if they've identified 2 years, and the applicant will know here that they'll only get 2 years and what occupation they've been nominated under. And then any family members to be included needs to be answered here. So in this case, our client has got partner and child. There's also just if they're bringing a child over, there's also a public interest criteria relating to whether or not the child is under the custody and care, and there's permission for the child to be removed from the country. So public pick 4015, 4016 cover that, whether or not the child, if so it becomes complicated if the applicant has a child another with an ex-partner, and the ex-partner either can't be found or hasn't provided permission for the child to be removed from the country, then it's possible in that situation that the department can't approve the child because they haven't been given permission to leave the country. That's just something to be aware of. So just some details. So these are all fictional details, by the way. So don't try to call or contact anyone. It's not going to work, hopefully. So any travel history, so any overseas travels needs to be identified, or any periods of residence overseas. That will go towards potentially both character and health. So if the applicants have been living in an overseas country for more than 12 months, then the department's entitled to ask for a character check from that country. Or if they've been in certain countries for more than 3 months consecutively, that might trigger a additional health component. So some applicants might not have to do health checks at all, but others might have certain check that they have to do. But if they've gone to a country where there's a bit of a higher risk of infectious disease, then they'll have to do a more involved health check. Okay, so just some details of the country of residence. I mean, where they have actually lived isn't, I don't think it's particularly critical unless there's a particular address that's in that country where there's a higher risk of health issues. But more so, it's the country itself, because that determines, whether there's a need for a character check or a health component there. So whether registration licensing is required. So registration licensing don't necessarily need to be obtained at the time of the visa application. The main thing is whether or not they're eligible to obtain the registration licensing. Okay, so whether or not they're entitled to receive the registration licensing. Okay, so again, I think they call it the SID skill assessment now, but they want evidence of the skills assessment having been commenced, at least at the time when the application is being processed or lodged. Then there's education history that goes towards checking if the applicant meets skills, qualifications, and experience for the role, and work history there as well. First, it's qualification. So if they've got a qualification, then it might show that they meet the qualification requirements under ANSCO, but they just have to demonstrate that. English language, if they've done the testing, then they should show proof of it. It is time of decision, as we mentioned earlier. It's time of decision criteria. So um, they just have to show that they meet the current instrument, which is 25082, at least at time of decision. Or they can claim the exemption if they've done all the secondary schooling and a few years of tertiary schooling, or all of primary schooling, a few years of secondary schooling, and they can get a certificate from the school that says that this was all conducted in English, then they could meet the English the exemption for the English language requirements. So just putting past employment details, obviously that's going to be quite critical because they have to show at least 12 months experience and also the relevant experience per ANSCO requirements. And whatever work experience they provide, department can always do a reference check. So they just have to be aware that, department. I mean, in our in our recent experience, we haven't had a client being caught up with a reference check, but it has happened. So it has happened, of course, on multiple occasions. Usually, when it's we find it more for trade occupations rather than professional occupations, mainly because there's probably less proof, and it's mainly just if, especially if it was cash in hand, then you need to make sure that whoever wrote the reference letter is aware, or the client needs to make sure that whoever they got as a referee needs to be alert that the department may do a reference check at any time. So any kind of payments made to the sponsor, they can't pay for the applicant under 482 can't pay for the sponsorship or nomination fees or any of the legal fees associated with sponsorship or nomination. The sponsor is on the hook for those. That's under the regulations. Okay, the sponsor cannot transfer or pass on any of the fees relating to any sponsorship fees, nomination fees, SAF, or legal fees, associated legal fees, onto any other person, including the nominee. Regarding the visa fees, visa application fees, and legal fees, that's open to be paid by either the sponsor or the nominee. But the sponsorship and nomination fees must be paid only by the sponsor. Okay. So this is an important question, which is whether or not um, whether or not the applicant wants to withdraw. So I think people make the mistake of selecting yes for withdrawal. What that means is if the nomination is refused or finalized, then the department will just take that as an indication that it's going to be, they'll just on their own initiative withdraw the application. They don't want that because if the nomination is refused, the department is required to send a Section 57 adverse information notice to the applicant inviting an opportunity to either withdraw or whatever they want to do with that application. Okay, that's generally, I'd expect that there is a legal requirement to do so because that counts as adverse information against the applicant that didn't form part of the visa application itself. So there's an opportunity to withdraw any time during this period anyway, before refusal. So if you select yes to withdrawing, you deprive your client of the opportunity to appeal the application. So I consider it to be a bit of a trick question. So just never pick yes for the withdrawal on the application form. There's always an opportunity. You'll have 28 days to make a decision about whether or not to, withdraw. You'll always get that opportunity. And if the department didn't provide that opportunity, that might be grounds to go to court to say that they deprive the applicant of procedural fairness because they have to tell the applicant, because a nomination application is separate from a visa application. And there's circumstances where the applicant just has no information about what's happened with the nomination application. And for them to know the reason for the visa application to be refused, they have to be given procedural fairness. So there's absolutely no reason to select withdraw application on the application form. You'll get an opportunity to withdraw if that's what the client wants. and also, claim a refund if it's withdrawn, or take it to appeal. Okay, so that's just something to be aware of. And also, you have to put in the details of the family members who also don't want to withdraw. Okay, so health declarations, just filling in all these details may change whether or not there's additional health requirements or health exam requirements. So, and then any kind of offending that needs to, because there's also a character element to the application.
In the recent applications,
Yep.
getting the HAP ID, is that the same with you guys?
So the question is, we're not getting the HAP IDs for recent applications. We Some applications just don't need health exams. So you check the EMI count afterwards and you see whether or not it says health exams required. Some of them say no health exams required, or they'll say health examinations finalized if they've done an earlier health exam that covers all the 42 requirements. Or they may allow you you know, to fill in to organize the health exams. So you click here to organize the health exams, and you fill in the correct responses, get the letters, and then organize the health exams. Or the other alternative is that the department will send health requests upon lodgement. So either way, you'll be at any time after lodgement. If health exams are required, then the applicant will be given an opportunity to complete the health exams, whether it's through organizing it by yourself through the EMI account, or the department has sent you those health request letters at time of lodgement.
How we process getting it.
Yeah.
Last few we haven't just got it. So
Okay. Well,
yeah.
oh, okay. Then you don't have to. If it just is cleared, you don't have to do anything. That means that health exams aren't required unless the department changes its mind.
So even though they have done it prior to 12 months.
Yeah. Yeah. If it's cleared, that means that health exams aren't required, at least until an assessing officer looks at it and decides that it is required, then they'll send you a health request letter. So if it says it's cleared, that means that you don't have to worry about health at all until advised otherwise. So you don't have to do anything about it. Okay. All right. So let's just have a quick look at hypothetical scenario. We'll try and cover this quickly so that we can move on to 186's. Okay, hypothetical one. So you've got Philip, who runs a vet clinic named Royal Pet Vet Needs, is looking to be approved as a standard business sponsor in order to hire veterinary nurses on subclass 482 visas. His company has previously been approved as subclass 457 sponsor, during which time he was advised to have workplace trainees in order to meet the training criteria. Philip approached the firm to inquire about prospects of being approved as a new subclass 482 sponsor. There's two vet nurses in his company. Is keen to sponsor as soon as possible. One a Chilean national and the other an Italian national. Philip wants to inquire whether you can start this process right away. He asked whether the fact that his organization has two trainee veterinary staff will help the application. So they provide some figures for the company. So the most recent financial year was about 2.68 million in revenue. Vet has 11 staff, and the payroll has been about 810,000. Clinic presently has a vet nurse employed with a base salary of 70,000 plus super. So Philip advises that each year, depending on the profitability, he states a bonus of at least 5,000. It's generally an expectation it can be paid out for each nurse, but it's not in the contract. So he just wants to know what concerns there are, whether he's okay to proceed, or what needs to be done. So what issues have come up out of that scenario? So back in the 457 days, I mean, there used to be these things called training benchmarks. Those who are operating around then would be aware of, where you pay 1% of total payroll towards training the Australian employees. The department found that to not be particularly effective in resulting outcomes for Australian, apprentices, trainees, and all that. So what they've done is obviously they've scrapped the whole sponsorship frame, the training benchmark framework, and replaced that with the SAFLEB. Okay, so his previous trainee vet staff don't really help to meet the training requirements because that's going to be covered under the SAFLEB. The question is, can he lodge? So he wants to be a 482 sponsor. He's got a Chilean national and an Italian national. Can he lodge a sponsorship right away? And can he lodge a nomination right away? So the thing with what's a what's a critical um, what's a critical nomination criteria? So with okay, let's cover sponsorship first. Right. So obviously as a sponsor, he needs to show lawful and active operation. He needs to ensure that there's no adverse information, that he hasn't engaged in any discriminatory recruitment practices. Relatively straightforward for the nomination. Before he can lodge a nomination, what will he need before he's eligible to lodge a nomination? Is he exempt from LMT, labour market testing? So, so yeah, so he'll need to have conducted labour market. I mean, Chilean national might be exempt. I think um, one of the particular, more than one potentially, free trade agreements cover Chilean nationals. So if it was just to hire a Chilean national, he might not have to do an LMT round. But for the other nominee, if it's going to be an Italian national, then there's no exemption for LMT. So he'll need to do 2 rounds of, or 2 ads lodged across at least 28 days on recruitment platforms, meeting all the necessary requirements soon. So each of them have to show the title or description of the role, skills and experience, name of the approved sponsor, and the recruitment agency. What's is there any issue with what he wants to pay the nominees? Let's say that he's offering a base of 75,000, and then let's say that it's the same deal, but it's a base of 75,000 and the bonus of 5,000, which he expects to be paid out every year, but it's not necessarily a assured thing, but he expects to pay it out every year. Is that going to be sufficient? So let's say instead of 70,000, 75,000. Yeah. So the market rate salary has to exceed, well, it's currently called the CSIT, so the core skills income threshold. So the which is currently sitting at 76,515, right? So right now, neither the base nor even with the bonus is going to cover it. But let's say he's willing to offer an additional 5,000 for the base. So let's say the base is now 75,000 and there's a contingent bonus saying, expected earnings every year. But is that going to be okay? Yeah, that's correct. So the bonus has to be guaranteed. So the others should just up the base to exceed the threshold, or whatever other guaranteed earnings, whether, however that might arise, whether it's, vehicle usage or allowance or anything, has to be guaranteed each year. Okay, so if it's contingency based, then it can't be counted towards the base salary or the guaranteed annual earnings, and the guaranteed annual earnings have to be above the CSIT. And then, of course, there's just the remaining criteria relating to all sponsorship and, well, primarily nomination requirements, which is depending on the scope of operation. Why? What's a CSIT? CSIT is the same as TISMIT. So CSIT is just the threshold. It's just called the CSIT now. But the actual figure is 76,515, which is going to be indexed to 79,000 something by 1st of July this year. So it gets indexed every year. Labor government's really keen to index the minimum salary each year. Yeah, so it's just a different. It's it is basically the Tisbit, but it's just for the it's for the core skills occupation. So anything below 141,200, 210, then you'd have to have a nominate an occupation on the core skills list. So it's just a different way of calling it the TISMIT, but it's essentially has the same function. Okay, let's just quickly do the second scenario and move on. So Liddy is a UK national who's been sponsored by Whole Dining Solutions for the position of supply and distribution manager. Whole Dining Solutions is a wholesale and delivery business that delivers catering solutions and scheduled pre-prep meals to client and fast food, fast casual retail business. Company's most recent financial statement in 2025 shows sales revenue of 5.6 million. The company had a previous manager resign on short notice in Feb 2026, and the business hopes to hire Liddy to take on a supply chain management role. The role was advertised on Seek with a title Supply and Distribution Manager. The company wants to know if this will meet the requirements for labour market testing under law. Description of key duties include the following. So they broadly reflect the previous manager's role, CEO. So they so he's mentioned that the manager is something of a jack of all trades kind of role. So it's a range of responsibility. So managing the company's supply chain needs, conferring with management on policies of supply chain, managing inventory and storage capacity, negotiating with suppliers on credit terms, creating lists of clients, pitching to potential clients and customers to secure sales, meeting sales quotas, managing, mentoring, and motivating the sales team, managing administrative tasks, checking quality and quantity of products, performing QA, quality assurance, and office administration tasks. So the company's going to offer 110,000 plus super for the position. They just ask whether the position's possible. So what's some considerations here? So Liddy, what's her nationality? UK national? Yes, yes, there is a L&T exemption for UK nationals under the AUK FTA. So the trade agreement between Australia and UK means that there doesn't need to be labour market testing. It's good. Um, so based on the role that's been nominated, supply and distribution manager, what are some considerations? Oh, yeah, you can always do labor market testing. So labor market testing is something that may assist an application by showing that there is genuinely no Australian local that's suited for the role. So, but it doesn't have to meet the statutory requirements. So it doesn't necessarily have to meet the, you know, two platforms across 28 days. But if some form of job advertising was done for the role, then that could be in support of a genuine position. Sales aspects in the job description are not part of the SDM occupation. Yeah, that's correct. Thanks, Ellen. There are a lot of, so that's why it's important to read the job description, because there's a lot of aspects of the role which seem to be not aligned with supply and distribution manager, such as mentoring the sales team and leading the sales team and actually meeting sales quotas. The department position about a role is that it has to substantially be, so sure, there can be a few peripheral duties or tasks and responsibilities that are carried out above and beyond the key, the main responsibilities based on nominated position. But it has to, the tasks and responsibilities for the nominated position have to be front and center of the role. So if half of these responsibilities are just not supply and distribution manager positions, such as sales or such as administration or just lower level non-managerial tasks and accountabilities, then then that might indicate that it's not a supply and distribution manager. So that's something that the client will have, or you have to go back to the client on and just clarify, can, what percentage of these tasks will be in relation to sales? Can we reduce some of the sales related responsibilities? Can it be more focally on supply chain management, supply and distribution? So that's important aspect of this. So for those who have checked the occupation list, supply and distribution manager has some caveats. Okay, so there's a couple of caveats to look at. So caveat 6, the position must not be in frontline retail setting or predominantly involve direct client and transactional interaction. So obviously if it's sales, then there's going to be a lot of direct client engagement, which would also go against the caveat. And then the position must be in a business with turnover of not less than $1 million, which the business meets in this case. But aside from that, I think that those are the critical issues of this case scenario. There's no issues with the market rate. Or it will be prudent to, of course, check the rates as based on what is shown in independent market data, such as job ads and salary surveys, to ensure that the salary offered of 110,000 for supply and distribution managers still matches the market rates or is equivalent to or exceeds the market rates for the position. And generally there'll be a range, there'll be a comfortable range that that the applicant ought to be able, like the company is able to show in our experience, which always, we never really had difficulty unless the salary is particularly low or skirting the edge. That's another thing for clients. It's advisable not to just get them to skirt the the bare minimum threshold. So we tell clients, sponsor clients, try not to just have the have the salary rate at the CSIT minimum, like 76,515, because then it's difficult to prove the market rates, because then the market rates have to not be under and not be over, and then you have to find a range that's just right on the precipice, and also may go towards genuine position and genuine need for the position. If they're just willing to pay the minimum, then there's two implications. There's the market rate implication, and also there's the genuine position implication, whether it's just being used to get a visa for the applicant. Oh, there's another case study, but maybe let's move on and we'll go through more case studies if there's time. Okay, so amendments from SID, I think we've just, this has been a while ago, so This is stuff that everyone ought to know. So it's just 2 out of 3 years prior to prior to application that you have. It's for the TRT stream. So so 2 out of 3 years prior to time of application for holding any of the subclass 482 visas. So unless it was one of the occupations instrument. Sorry, some of these might be redundant. That's why I've just past gone past it. But the TRT stream, TRT stream is more or less the occupation doesn't have to be on the occupation list anymore. So the occupation doesn't necessarily need to be on 24093. Even if it's no longer on the list, as long as the applicant holds a 482, they can transition towards the 106 under the TRT stream. Okay, so they should just write these T, T, and then in direct entry stream. And then there's also, sorry, there's also a labor agreement stream, which, as we mentioned, sits outside the standard framework. So it's only under the direct entry stream that the applicant needs to have occupation on the occupation list, which is the CSIT list, the CSOL, same as the 482 list. And they need a skills assessment and at least 3 years of full-time work experience. Okay. So other criteria, they need to show competent English, which is 6.0 in each band of IELTS or equivalent. They need to be under 45 unless exempt. They need the valid skills assessment unless exempt. And then if there's registration or licensing, they need to show eligibility for that. Ideally, if they can just hold the registration licensing, then that should prove it. And then there's a range of public interest criteria that applies the same way. And member of family unit criteria needs to be met also. So that's all covered. So it's primarily nomination criteria. Again, I'm not going through all of this because a lot of it is just something that you can read in your own time, but a lot of it is just updates as well. Now, one thing to mention is that there's no limits to the amount of 482 visas one can apply for. You can continue to apply, particularly for those who don't have a pathway to permanent residency, can apply to renew 482 visas if each round you can show that the genuine position and genuine need for the position continues to apply. But at some point, one will need to, there's a particular point the department may no longer accept repeat applications. So if there are any outstanding concessions to be sought, such as age concessions, then maybe a labour agreement is a way to go to ensure that the applicant who's like over a particular age can have a pathway towards permanent residency. Okay, so just covering some exemptions now. The exemptions are all under LIN 19/216. So valid skill assessment, unless it's an academic applicant or a science applicant or a 444461, which is a New Zealand citizen who or their partner. So academic applicants, those appointed as faculty heads or university lecturer at particular academic classes. Science applicants are employed as a researcher, scientist, or technician within a government, science agency, or a university. So those types of applicants, you don't need to necessarily show a skill assessment for the direct entry. So English requirement, there's no exemptions. So just be aware there's no exemptions. The only exemptions you're going to be able to get, or concessions, not even exemption, will be under the labour agreement stream. But the age cap exemptions apply for, again, for science applicants, academic applicants, particular legacy 457 workers, so those who actually made an application 457 before 18th of April 2017 and were in Australia during particular COVID periods. So there's maybe a small cohort of people who are still under that um, under that exemption. Regional medical practitioners, so someone who's worked as a regional as a medical practitioner, so ANSCO minor code 253, um, nominees who are over 45 get a chance to apply. And then the most critical one will be the ones, well, the most common ones are most likely the ones who are paid the Fair Work High Income threshold. So they have to be paid for at least 2 out of 3 years, matching whatever the Fair Work High Income threshold is for that year. Just to note a point about the Fair Work High Income threshold and the period assessed. It's the period immediately before time of application. So if the applicant lodges in April of 2026, then the period assessed for the Fair Work High Income threshold has to be, April 2025 to April 2026 or April 2024 to April 2025. And it's whatever the Fair Work High Income threshold is for that particular year. All right. So the applicants are in the worst. I think if you're talking what's more advantageous for the applicant compared to what's worse for them, they're probably at the worst position if they apply on or after 1st of July, because then the Fair Work High Income threshold is for the new year. And the indexation can be quite high. It could be 5,000, it could be 8,000. So unless they're comfortably above that Fair Work High Income threshold, if they're sort of just on the edge of it and they feel like they could just index maybe 5, but sometimes the jump is quite significant, and then they have to meet the Fair Work High Income threshold for the new financial year. So the best time they can apply for it is probably, assuming they meet at least 2 of the 3 years, but is probably around June of the financial year, because then it's still that old threshold and they can be quite assured that they'll cover it in those particular financial years. So just something to be aware of if wanting to claim that exemption, especially for the clients who really just want to stay on the precipice of meeting the Fair Work High Income threshold. Then for direct entry stream, the age limit exemptions are for academic and science applicants and the New Zealand 444461 holders. Okay, so the English language tests was the new requirements were set on 7th of August 2025. This is the new English language providers. There's adjustment of some of the scores. For PTE and for some of the other scores, there's been a bit of adjustment, but tests taken before that date can still be counted, before 7th of August 2025 can still be counted as long as it was made in the 3 years prior to the application. Okay, so yeah, the table is there for further review, and also any UK, US, Canadian, New Zealand, or Irish passport holder are deemed to have competent English. So that's the only existing exemption for English language, if any. So just family violence provisions. I briefly mentioned it at the start. I don't have to go in too much detail because it's a bit more, it has a bit more complexity to it. But essentially, if only for the 186 or for a permanent visa application, if the family member has suffered family violence committed by the primary applicant. So, and the primary applicant has either been granted a visa or been refused a visa because of, and part of the reason for the refusal is because of family violence, then um, those family members can actually apply on their own for a visa. So the criteria for the family violence, and there's no fee for it, and the criteria for it is similar to the family violence that applies to partner visas. So family violence, um, the family violence, sorry, the family violence scheme applying for partner visas where you need the statutory declaration in either two items of either judicially determined acts of family violence or non-judicially determined. So judicially determined acts being ones where the perpetrator has been charged with a offence and convicted of offence involving the family violence, or otherwise has had an intervention order made against them by a court. Non-judicially determined would be having the applicant need to provide a stat dec and two items of prescribed evidence, witness evidence of family violence. Okay, so just some of that information is all there. All right. So that's all 186. And then we're just moving on to the subclass 494. So that's just the regional framework. Um, regional framework borrows from both the 482 and the 186. So there's elements of both, of course, with a standard business sponsor. It's the same. So the SBS is the same. Okay. So if the applicant has a standard business sponsorship by reason of a 482 application, that's the same sponsorship approval for the purposes of 494, the regional sponsorship. But then once we get down to the nomination and the visa, then I think the 494 borrows more elements from the 186 there as well. Sponsorship criteria is all, so just get past that. Labour market testing will be necessary, so there's no exemptions to labour market testing for 494. So just being aware of the fact that labour market testing will always be necessary, but you can still do select occupation or select position. So if they're in any of the particular categories, like a top talent chef, sports person, um, or if it's associated entity or one of those particular select occupation, select position categories, then labour market testing just requires a letter from the sponsor rather than having to do the two job ads published across 28 days and such. Labour market testing for a 494 is mandatory, but there is still a concession for what's called select position and select occupations. So that's in that labour market testing instrument. Off the top of my head, I can't recall, but it might be 18/036 or thereabouts. But select position and select occupations means that rather than having to do the labour market testing, the sponsor just has to write a letter explaining why there aren't Australian workers suitable to be filled in the position. Okay, and that applies for particular categories, select position and select occupations. I think ambulance workers is one occupation falling in that category. I think if the salary offered is very high salary, so over 250,000, things like that, or they've got a associated business that's operating from overseas, then you can just do select position. Or if there's a nomination just to change the salary, then you don't have to do the labour market testing. You just have to, that's a select position or select occupation where it's you just provide less. It's not like you don't provide anything. You still have to provide an explanation, but you don't have to do those prescribed job ads. Yeah. So 494 and 482 both have select occupation or select position concessions. And I'll call them concessions rather than exemptions. But the 482 has international trade agreement exemptions, but the 494 has no, um, yeah, ITO exemptions. Okay. So the position must be located in a designated regional area, which is essentially an area outside of metropolitan Melbourne, Sydney, or Brisbane. Genuine full-time position. So there's a bit of a higher threshold for the 494, which is that you have to demonstrate the position will exist for at least 5 years. So that's most likely going to be seen through an established business that's been operating for a while and is also operating profitably, and there's a history of its operations being profitable. So the scrutiny of the financial capacity of the company is going to be greater for the 494 because of the requirement for the department to be satisfied that the position will exist for an additional 5 years, meaning the sponsor has to exist for an additional 5 years with the nominee employed, which invariably means showing the financial capacity and the fact that there shouldn't be any concerns about the financial issue, any financial issue. So that also goes towards the challenges in if the sponsor wants to use a startup business to sponsor under 494, that's going to be more challenging because of this particular criteria. Then the employment arrangement's still similar, so they still have to, have an employee agreement, unless there's, unless it's in that category of CEO or whatever. But market rates also, and then the sponsor also needs to get regional certifying body advice on the market rates so they'll certify whether the rates to be offered to the nominee will align with the relevant market rates for the position. Okay, so just designated regional area postcodes, that's all been set out under the instrument here. Visa application process, so very similar to quite similar to the 186 actually. So you need an approved nomination, you need valid skill assessment unless exempt, so academic applicants usually. No, so at least 3 years work experience, full-time work experience, that's skill level required. Then the age cap of 45 still applies. Note that the age cap for the 494 applies for the 494, so at prior to lodgement of application. It doesn't apply to the 191. So if they manage to squeeze in one of these applications and get that approved, then it doesn't matter how old they are when they apply for the 191, which is a PR visa that follows from the 494. And then public interest criteria, special return criteria, member family unit provisions. One thing about member family unit, just to mention, is that for the 186 and for the 494, there is one fail, all fail element to it, particularly for public interest criteria relating to health and character and bogus documents and false and misleading information. So if one included applicant has issues and they fail the criteria, then all applicants can't be approved the visa. However, that the character and health applies also for non-migrating dependents. So members of family unit. So even if you're not including a partner or children, they still will be required to show that they don't have any character or health issues. They may be requested to do health exams and such, so that it doesn't matter if they're included as part of the application or not. And if they fail it, then all actual applicants also fail. Just be aware of that. So exemptions for the valid skill assessment. So just academic applicants and New Zealand visa holders. no science applicant exemption. So just be aware it's a bit different from the 186 exemptions. Um, the age cap still, most of the exemptions are still relevant. Question: what if their family members will not attend medicals or PCC? Yeah, that's a difficult one because I mean, if it's their partner, so I think with partners it's fairly straightforward, right? Because they're your partner, and if they stop helping you, then maybe they'll stop being your partner, and then they're no longer a member of family unit. But with children, then obviously there's sometimes people have children that they no longer are in contact with, then it becomes difficult. I think the way to go about it is essentially to put to the department that certain family members are no longer, you know, no longer part of the family member cohort, or it's just not possible to reach them if they've just disappeared and there's just no way to identify them, or there's just no, you know, no permission is given to um, get their medical exams, and then and then the argument would be essentially whether or not they're a member of family unit anymore. Um, but it is within the department's, prerogative to request, because the criteria is a one fail all fail criteria for non-migrating and migrating family members. Yeah, I think I mean, it's an inquiry that needs to be made. If it happens, then submissions can be put about the difficulty in being able to locate them, and then maybe, you just put a certification saying, as far as I'm aware, like a stat deck saying as far, because the criteria isn't necessarily that they have to complete a health check. The criteria is whether or not they fail the medicals. So if you sort of put submissions and say, like, we can make a declaration that they don't have any health requirements, but I there's no way for us to obtain these health checks for certain applicants, then that could be accepted. Or otherwise, if the department is just being really draconian about it, you can always take it to the tribunal, make the same argument. Worst comes to worst, just take it to the minister for ministerial intervention and say this is quite unreasonable. There's no way to get those health checks, and I've got no contact with this person or no permission. So naturally, it's unlikely that they'll ever migrate here anyway under under the umbrella of my sponsorship. So um, maybe the minister can intervene. Okay, so we've talked about exemptions for age for the 494, which is quite similar to that of the 186. So just be aware that anyone who holds a 494 can't apply for 3 years for any of the other PR subclasses that they could otherwise qualify for. So any of the skilled migration, business skills, um, the NIV, and partner visa. So they won't be able to apply for those visas for 3 years once they hold a 494. And that's to enforce, that's for the department to sort of ensure that they commit to the 3 years that they said they would live, work, and study only in a regional area. Okay. So 494, de facto partners are subject to the 12-month relationship or have to get a relationship registration. So permanent visa holders and a range of other skilled migration. I think for 186 and 494, both of them have that. So if they're a de facto partner, then they have to meet Reg 2.03a, which is either show a de facto relationship for at least 12 months or otherwise have a relationship registration if they're de facto partners. 482 doesn't actually have that. 482 just has that they're de facto partners, so that the proof isn't so stringent there. Um, yeah, and then there's work visa conditions. So the key condition here is 8579, which is to work, study, and live, work, and study only in a regional area. And in order to qualify for the 191, they have to have full compliance with condition 8579, which is to live, work, and study in a regional area. The rest are all substantial compliance um, requirements, but there needs to be full compliance with the regional stay or regional presence. Okay, so we've reached the end of the content, so maybe let's go back to doing some case studies. Okay, go to case study 3, which is clinical strengthening. Okay. So since we've got a bit of time, maybe I'll give everyone about five or so minutes to just have a look at the rest of the case studies, um, and then we'll come and work through them all together. Okay. Hello, everyone, again. Um, I had a chance to have a look at the case studies, so let's go through them. So I got case study 3, which is clinical strengthening, is an approved subclass 482 sponsor, which hopes to nominate certain candidates in physiotherapist positions for the business. Business advises that recently job ads were published by the business on the websites LinkedIn Premium and Seek. The ads ran for 3 weeks and contained the following wording. So, sort of got physiotherapists wanted, their growing physio practice position is opened up. They'll receive this salary, access to mentor, state-of-the-art facilities, welcoming, highly engaging work environment. Looking for candidates having these qualities: so strong passion for physiotherapy and musculoskeletal strengthening, discipline, highly care focused, results driven mindset, strong team player. So ARPA registration is necessary if the role's for you. Click now. So CEO of the company, Arnold, attends your office to discuss the requirements. So he advises about 6 months ago, the business actually made about 4 physios redundant because of a general downturn in business. However, 2 months ago, the business managed to secure a major contract to be the exclusive physiotherapy and sports medicine provider for a major VFL sports club. So they're keen to secure additional staff members and asks about the situation so far. So any thoughts on, well, they've provided the job ad in that specific format, and then whether or not there's any other thoughts on their position and what they'll need. Are we happy with this job ad, firstly? Does that look like that would pass muster? Why or why not? Yeah, LinkedIn. It's published on LinkedIn. It's published for only 3 weeks. 3 weeks is not sufficient. That's right. So if it's just 3 weeks and it wasn't, there's no way to add additional week. Okay. There's no gaps that are allowable for labor market testing. So any gaps in between means that the sponsor's kind of having to start from day one again, and then sort of publish the job ads. But of course, that also gives them an opportunity to fix up the job ad, because it's, what do you think is also needed in this job ad? Does not refer to specific skills for the role. Yeah. So it just asks for strong passion, you know, highly care focused, results driven mindset. Optimally, a job ad has to include qualifications and work experience. So, mandatory aspects of job ads should have that. And also, it doesn't really describe much of what the role requires. So I think that while the statutory requirements, there's a title or description for the role. If you just to be on the safe side, I'd recommend putting in all of the tasks and responsibilities for the position, or at least the key tasks, between 5 to 8 key tasks and responsibilities for the position itself. Okay, so fix up the job ad. Is there anything else to be considered? Job ads must be placed through the employer's MyGov account at the time for the position. Yep. So a few different things. That's good. So it doesn't say full time. Yep. So we have to specify that the role is full time. The job ad has to be in English, which is met. So it doesn't necessarily, job ads can be advertised through Workforce Australia. I think that's a government job ad site where people go through the MyGov ID and publish. So that's one option that's definitely going to be accepted. and you can advertise for 4 weeks, and also um, it doesn't cost anything. I think the issue with Workforce Australia is just, at least from feedback given, it's just the fact that it's really not really intuitive to deal with. As in, you have to go through all these different technical hoops with the phone and with the website, and having to call, the service to get that organized. So the setup for Workforce Australia is quite onerous for an employer. So that's why they like to use established websites more often. So Seek, Indeed, um, Career One, Azuna, those kinds of websites would be good. Just another note that accredited sponsors can actually advertise on their own website. So in the instrument, they said that accredited sponsors can advertise the role on their own website. I guess the challenge is being able to show that was published for 28 days and how applications are received. But so that's a concession that's offered to accredited sponsors, which is good. So length of time for the position, that's not necessarily, um, yeah. Oh yes, location is also important. I guess you need to identify where the position is to be performed. That location of a position is also relevant in the assessment of market rates, because the department also considers that the market rates must be on the site, not necessarily the location of the sponsor's head office, but it has to accord with the market rates relating to where the role is going to be performed. Um, so it's also important to know location for that purpose. Length of time for the position doesn't necessarily need to be specified. I mean, it can just be an ongoing position. I mean, if it I can conceivably see it having some assistance to show that a position is only intended genuinely for a temporary period. If you say role for a 2 year, 1 year, 2 year stint, um, then that could show that the role is intended for a short-term period that aligns with the 482 framework, but it's not critical. So another thing to mention is the fact that the company made certain physios redundant, 4 physios redundant 6 months ago. So that is likely that would you'd want to address that. You'd want to be able to explain why the business now, given that there was clearly no shortage for 6 months ago, so 4 physios could be let go. But now suddenly with the pickup of the new business, um, then it might be now the business does in fact need additional staff members and doesn't have any on hand. So that's why they have to advertise and potentially look at sponsoring. Okay. So we can go to the next case study. All right. Debbie and Grace. So Debbie's a 482 visa holder from the US. She's sponsored by Cosmo Lighting as a global sales representative or sales and marketing manager. She would like to bring in her husband, Gene, and her 2 children, Donnie and Kelly, to Australia. Donnie is 18 years old and Kelly is 25. Debbie advises that Donnie has cerebral palsy and requires regular medical support. She's not sure whether or not this will have any impact on their ability to be granted a visa. Debbie also advised that her husband Gene has had some issues with drinking, which has led to some problems with the law. He's previously been convicted of a drunk driving offence in October 2003, for which he received a fine and suspension of license. In August 2005, Gene had another drink driving incident and was sentenced to a 48-hour jail sentence, a fine and suspension of license. 2006, had a fight with a patron in a bar, sentenced to 6 months probation, requirement to complete an anger management program. Then in January 2008, he got into another fight with a patron in a bar and was sentenced to 3 months prison. Since Sanjin has sought therapy for his drinking problems, taking all efforts to stay sober and keep out of trouble. He has not committed further crimes or had any further convictions. So he's so Debbie's asking what are the what are the implications facing her family members, if any. So can she bring her family? Can she include her family members in her application, or can she apply for them to join her as dependents, as secondary visa applicants? And what issues, if any, arise here? Okay, let's just firstly start with Kelly. So Kelly is the oldest child, 25 years of age. Can she include Kelly in an application? And why not, if not? Subsequent entry requirements. So it's called a subsequent 482 visa, but they'll need to meet the secondary criteria for the visa. So under Schedule 2, well, they'll need to meet Schedule 1 and Schedule 2, but the Schedule 2 requirements will be the secondary visa requirements. So can Kelly apply as a secondary applicant for Debbie's primary application? Not a member family unit. Yeah. And that's because of her age, right? So it's either they're under 23 or they're under 18, actually. That's the simplest. They're under 18 or they're under between 18 and 22, and they have um, a substantial degree of reliance on the head of the family for clothes, accommodation, food, and clothing. Or if they're 23 or over, then they would have to show some kind of whole or total, total part or total incapacity to earn a living. But doesn't seem like Kelly has any health issues, so she'll need to have her own pathway. Okay. What about Donnie? Is there any issues for Donnie? He's got a cerebral palsy, right? So he might have to meet certain health criteria that may be assessed by the department. If he's reaching the threshold of significant costs, the treatment. So with the health criteria, then it's a question of whether they would exceed significant costs or cause prejudice to the Australian community. Prejudice to the Australian community, so like critical medical um, supplies and resources in the Australian community includes, for instance, if they require some kind of organ transplant or dialysis or something of that nature. Significant costs is if the MOC, so a medical officer of the Commonwealth, assesses the applicant to exceed the significant cost threshold. So the significant cost currently benched at $86,000, and it's across the period of time that the visa is granted for. So for the 482, depending on how long 482 is to be granted for, it has to the total cost must be assessed as being potentially not greater than 86,000 for that period of time. So, and it's the assessment is an objective assessment. So the objective assessment means that they assess the form and level um, of the condition, but they must also consider whether or not it's so they consider the level, but they don't have to consider whether the applicants will or actually will claim those costs or not. It's an objective assessment is just whether someone is able to, or you know, someone in that position may require such costs. There is cannot meet pick 4005 or 400. So the 482 has a 4007 component to it. So 186 direct entry is 4005. So then that's less room to move. But for the 482, it's 4007. So you can still argue that it's a waiver, even if there's a significant cost threshold that is one of the applicants is impacted by. The waiver can come, the arguments to be made about there not being an undue cost um, is whether there's mitigation for the fees, whether the sponsor sort of supports privately funding the fees, and whether there's compelling reasons, compelling compassionate reasons that be in favour of a waiver. Okay, so Donnie's gonna have to deal with that. And what about Gene? What issues does he have, given his prior bit of a history with the law? So potentially, I mean, there's a need to meet the character test. So that's pick 4001, but also section 501 of the Migration Act, which applies to any applications made. Given that his all the offending is done quite a long time ago, though, that should count for something, right? So a lot of the arguments put forward would be while there was a period of offending that was almost 20 years ago and it wasn't particularly serious. I mean, there was um, there was a brief period in prison, but I think the more critical aspect is the rehabilitation that's been accomplished over the years and the fact that he hasn't reoffended and the risk to the Australian community remains, you know, not high enough to disqualify him for the visa. So each family member in this case scenario has particular issues that they have to consider and address. But not insurmountable. Then finally we've got Lucy and JT and YM. Okay, so Lucy is a subclass 482 visa applicant. She was nominated as a fashion designer for a sponsor, JT and YM, a boutique manufacturer of casual apparel for young men and women. She was initially sponsored and approved for a subclass 482 visa on the 3rd of January 2023, the expiry date on the 3rd of January 2025. Prior to a 482 expiry, she was sponsored again for a second 482. She was approved on 20th October 2025 to expire in October 2027. Sponsor, along with Lucy, would like to discuss the prospect of any permanent appointment, concern with the occupation of fashion designer not being on the current occupation list. So they just want to make sure that they've got the options correctly. Company disclosed that its most recent turnover was around 7.5 million. Lucy's 36. She's an Italian national, completed what PT a year ago, which confirms the score as score set there. She has a partner, Nico, who's also an Italian national, and a young son, Francis, presently 15 months old. Francis' mild asthma, the family only managed to diagnose 3 months prior. So they just want to discuss options. So even though it's not on the current list, or better check if it is, but what's is it, does that, regardless of if the occupation is on the 186 CSOL, does it matter? Doesn't matter, right? Because she can access a TRT stream. So just whatever occupation, it just has to be the same occupation that she's been working in, that she has worked in for at least 2 years out of the past 3 years. Okay. What about, is her English sufficient? So there's been a change in the English language tests. but she completed the yeah, she completed the test 1 year ago. So um, that was before the new English the instrument came into effect, and it's still within 3 years. So it'll be assessed against the metrics um, of the prior English language test, in which the PTE requirements were 50 in each band to show competent English. So shouldn't be any issue there. She's got a son who's diagnosed with mild asthma, but assuming that they may raise a mock consideration, that's kind of have to wait for the mock to make an assessment on that. And if they do, then it's given that it's one fail, all fail uh, criteria for the 186, then they'd have to address why it ought to be. And I think for the TRT stream, it's pick 4007. So they'll at least have grounds to argue a waiver. Just note that there's a difference between the TRT and the direct entry, being that the TRT has the waiver, no, leading on from the 482, but the direct entry doesn't have a waiver. It's pick 4005. Okay, well, that covers all the content, and it covers all of our, uh, you know, case studies and discussions. So, does anyone have any questions they want to raise? You can always send me an email after the fact. Can I obtain a copy of the recording for webinars? And oh, that you'll have to ask our office. I'm not sure if I have the authority to give you certain materials, but certainly if it's yeah, it's been a pleasure presenting from you. We've got a partner visa session, I believe, this afternoon, um, and then another student and 485s tomorrow. And for those who need to complete ethics and code of conduct, that's also tomorrow. But if you have any questions, just shoot them all through through my email. And um, thanks again for attending. Hope you've learned a few things, and I'll look forward to seeing you all at the next one. Thank you.